Welcome all to the second panel of our graduate program opening week. Before we start, I need to read some disclosure information. So all statements expressed by Fundação Getúlio Vargas employees and guests in our online events and broadcasts exclusively represent their opinions and not necessarily FGV's institutional position. We also reiterate that everyone present here agreed to participate in this event of their own free will, and they consented to be recorded in this broadcast, which will be posted later on FGV's official channels. As in the previous sessions, panelists today will share some results of the Lex Atlas COVID-19 academic project. Particularly, this panel is entitled Pandemic Responses, a comparative discussion of Latin America. And we will have presenters discussing responses in Mexico, Argentina, Colombia, and Brazil. I will introduce the panelists and then pass to our dean, Professor Oscar, who's here today for his initial remarks, and then to Otávio Ferraz, so he can explain a bit more about the project. So our panelists today are Pedro Villarreal, Senior Research Fellow from the Max Planck Institute, Roberto Gargarella, Professor at the Faculdade de Direito de la Universidad de Buenos Aires, Madalena Rocchi, Lecturer of the Faculdade de Direito de la Universidad de Buenos Aires, Maricela Ossar, Lecturer at the Faculdade de Direito de la UBA, Diego Gonzalez, Deputy Justice at the Constitutional Court of Colombia and a Professor of Constitutional Law at Externado, and Otávio Ferraz, co-director of the Transnational Law Institute of King's College London, and a senior global fellow of our school. Oscar, the floor is yours.
Good afternoon, everyone. It's a pleasure to be here with so many people that I have long been friends with and new people that I'm having the pleasure to meet here. It's wonderful to be with you. In fact, Raquel said that I would make some initial remarks. I will not interfere in your conference. It's just because this morning I was supposed to be here to do the opening of the event, but I had a doctoral committee at the same moment that was set many months ago, and I couldn't escape off. So I'm here, first of all, to excuse myself for not being here before in the morning to welcome you. And so I'm doing this at this moment. I would like to really appreciate your time, your disposition to be here with us in the opening event of our doctoral and master's program. It's wonderful to have all of you here, and also to initiating some very interesting projects of research. And the presence of Otávio Ferraz here means not just that he's visiting in our school, but he's a member of our community, and we are working together in so many projects. And the one that you're going to speak to this afternoon is really part of this. As you know, this school started around 20 years ago. We have doubts about the date of our foundation because we have so many projects, but we can say 20 years ago this school was started. And when it was the decision to create this school was not because Brazil didn't have too many law schools. At that moment, we had already 980 law schools around the country. Decision was more based on the idea that even though we had wonderful law schools in Brazil, there was a necessity to understand and to rethink a way to do legal academics in Brazil. The idea of having full-time professors really dedicated to research that could create a more independent body to do research in legal thinking in Brazil. So that was one of the reasons why we decided to go for and build this law school. this program, the program of doctoral and master studies in law and development, is the part inside of this school that really takes it seriously, more seriously, this decision of reshaping legal thinking in Brazil. Not just because people would provide more time for research, but also that people would take facts into consideration when thinking about law. So I really appreciate your disposition to be part of this week, to come to São Paulo, even if it's only virtual, to discuss with us some of the key issues that are being on the agenda of this program. And I really would like to appreciate the presence of Otávio, my dear friend, Roberto, also a long time not seeing you, but it's wonderful to see you here. And welcome all of you to our program. Abraço a todos.
Thank you, Oscar. We'll pass the floor to Otávio then.
Hello, everyone, and thank you, Oscar, for these initial words. As I was saying in the beginning today in the morning, I'm happy about this opening week for several reasons, and one of them is because my collaboration with FGV as a senior global fellow can finally start more officially. And it's a shame that I'm in São Paulo, sitting in my mother's flat at the moment and cannot be with you at GV, but I hope that very soon this will be addressed and we will be able to meet in person again. As I'm hoping to do that very soon as well with Roberto, who I haven't seen for so long now as well, although we do see each other from time to time virtually. In events, and with all the others here who have very generously accepted to participate in this project, which I'm co-leading with Professor Jeff King from UCL, and with the collaboration of the Max Planck Institute. Pedro Villarreal, who is here with us today, is the main person there. And it's really nice to see and meet Madalena, Maricel, Diego Gonzalez for the first time, and you, Raquel, from the Fundação Getúlio Vargas, and I hope with you it will be easier for us to meet in person very soon as well. So this table is dedicated, as you know, for a discussion about Latin America, in particular Argentina, Colombia, Mexico, and Brazil. The rapporteurs, and I will explain what that means, from Lex Atlas are all here, and I am the rapporteur from Brazil. So I'll be speaking more substantively at the end as well about Brazil's response to the pandemic. But before that, I just wanted to use a few minutes to explain what the project is, so that everyone who is here today watching us in the YouTube channel can understand a bit better about the project before hearing about each of the countries which are present here today. So please bear with me just a few minutes for me to introduce you to the Lex Atlas COVID-19, or LEC-19 as we call it, which is a comparative project of 60 countries around the world in their response to the pandemic, but through the prism of law. That is, the legislation adopted to try to address the pandemic, and also the judicial action that may or may not have taken place. It varies a lot across countries, as you would expect, involving the response to the pandemic. So the idea is to make a comparative inventory, that is to map out, and hence the name Lex Atlas, to produce an atlas, if you will, of the thousands of constitutional, legislative, executive, and judicial norms that emerged around the world in an attempt to contain the pandemic. So that's the first aim of the project, to map out the responses, and then also, and equally important, to analyze the impact of these norms on the rule of law and human rights, and vice versa. That is, how did the rule of law principles and human rights norms influence, if at all, the response to the pandemic in so many different countries? So for example, through what legal instruments were anti-pandemic measures adopted? Emergency declarations, ordinary legislation, executive decrees, a combination of all of those. We had in the morning a really interesting panel about emergency declarations, and Professor Jeff King, who is leading on that aspect of the project, showed how it varied significantly and interestingly across the world, how countries did or did not declare emergencies to enable them to address the pandemic. Another question, was there democratic debate about these measures, or a more authoritarian imposition of such measures? Again, it varies a lot across the countries. In many countries, we have seen even non-authoritarian countries, at least not like formally so, what we called pandemic opportunism. So leaders using the pandemic and their response to the pandemic in a way to try and consolidate their power and abuse their power. Another question, were the restrictions imposed proportionate? That is, did they respect fundamental rights? How was the right to protest respected or not during the pandemic? We know that some of these public health measures impact very significantly on the ability of people to gather together, and that has a very important impact on the right to protest. Last but not least, were social rights such as education, work, food impacted by the so-called lockdowns, and so on and so forth. So these are just some of the numerous questions that the LAC-19 wants to help to answer. And to do that, we assembled a team of experts across the globe, the so-called country rapporteurs, many of which are here with us today, who are in the course of producing country reports of about 20 to 25,000 words for each of these 60 countries. And these country reports, that's very important to emphasize, they follow the exact same structure. They are divided into 6 parts, and the country rapporteurs are asked to respond to the same set of questions in each of these parts. These questions form part of what we call the author guidance code that all of the rapporteurs received to produce these reports. And through that, we are attempting to achieve consistency across all of the reports, which will ultimately enable a more scientific comparison of these countries, different to what would happen if we had like freedom. So each rapporteur could produce their own reports according to whatever they believe is the best manner. So I know that some rapporteurs felt a bit straitjacketed in that framework, but we explained that they had freedom within that framework to highlight what was more or less important in their own country. And I think after we explained that, things ran much more smoothly. So the idea was not to freeze rapporteurs and produce an anodyne kind of report for each of the countries. It was just to try and assure some scientific rigor in the comparison, but also freedom for each of the rapporteurs to write their own reports and highlight to us particularities, interesting political context of their own country. And I'm happy to say that it's been really successful now. We have published, our aim is 60. We have currently 39 reports published in the Oxford website, and this is something else I wanted to tell you about. So can you see my screen or not? No, okay, so let me try again. They stop share and share again because the same problem happened earlier. Now?
No.
Okay, so that always happens. So I will just mention that this is all done open access. So one of the main principles that we decided early on in the project is that we will do that open access. So we were lucky enough to have a large grant, partly from the Max Planck Institute, the King's College Law School, and the UCL Law School, but partly and much more generously from the United Kingdom Research and Innovation funding body, which allowed us to purchase at a cost price from Oxford University Press, open access to all of the reports. So if you Google Oxford Compendium of National Legal Responses to COVID-19, which is what I wanted to show you, you can go there and access any of the reports of any of the countries involved in the project. Now, as well as these reports, we are also organizing data and analyzing the data in the several thematic areas. So we have a fully dedicated political scientist, Dr. Andrew Jones, who talked this morning about legislative scrutiny of pandemic regulations, who is doing that for us. And together with his expertise and our team, we are going to produce what we are calling data sets on several specific themes. I've mentioned already emergency declarations, legislative scrutiny. We also have mandatory vaccinations, respect for human rights, respect for rule of law, impact on elections, and many others. And this data will be available in our own website, which is called lexatlas-c19.org. And there you can have access to all of this information as well. So to finish, the aim of the LAC-19 is to create a resource where anyone interested in knowing in a much deeper and accurate detail to what you can get from fragmented reports in the media or in other resources that are around. So in the same resource, deeper and accurate detail about what a country's response to COVID was, and also understand why a certain country adopted a particular response and not simply what response it adopted. So to give a couple of examples that I mentioned in the morning, Sweden was highlighted in the beginning and still is as a country that adopted much less strict public health measures than, for instance, its neighbors in Norway or Denmark or the UK or even here in Brazil. And the LAC-19, with a team of experts from Sweden, has produced a great report where you can understand why Sweden has done that, how the legal system in Sweden has determined in great part why they took a different approach, rather than just the more anecdotal things you hear sometimes in the press. Oh, Swedish people comply with rules anyway, so we don't need these laws. It was actually the opposite. Cases and deaths in Sweden skyrocketed compared to the neighbors, and in the end they started adopting more restrictive measures, and that had a lot to do with the legal and political systems, which you can learn if you read the Swedish report in the LAC-19 website. And like that for many other countries. I won't be much longer here because we are hearing about 4 different countries here, and I'm sure that after you hear from them, you'll see how the LAC-19 operates in practice. So the Swedish example is just one of them. So just to finalize now, before we hear from these great people who are already here with us, the LAC-19 teams now are spread across the world with 60 different teams in different countries and more than 200 experts, jurists from public law, public health law, and some other areas involved in the reports, preparing collectively this collection, which anyone interested either in a single country's response or in comparing different countries can easily consult through the website of Oxford University Press or our own LAC 19 website. So I hope that people watching us today will go there, click on those reports, use them, and carry out their own analysis of what happened during this pandemic in any particular topic that you may be particularly interested in. So thank you very much again for FGV for this opportunity, for all the panelists who are going to speak here now, and back to you, Raquel, to carry on with the proceedings. Thank you.
Thank you, Otávio. Just before I pass on the floor to Pedro, let me just tell to everyone who are watching us that you can send your questions through the link that is below the video. It goes to a website called Slido. So please send your questions in our direction. So Pedro, to you.
Muito obrigado, Raquel. Muito obrigado. Muito obrigado pelo convite. Lamento não poder falar em português, so in order not to embarrass myself, I will continue in English today. And I would like to thank, of course, Octavio Ferraz for the invitation, Professor Vilena and Raquel Pimenta for having us here today at the Fundação Getúlio Vargas. And I will share a PowerPoint presentation for today in order to proceed with my talk. I trust you can see it, and otherwise please stop me. Today, and after Octavio's wonderful presentation that set the scene for our discussion, I will focus on Mexico's legal response to COVID-19 within the Lex Atlas COVID-19 project. On the one hand, I was area editor for international and comparative health law, and on the other hand, I was the country rapporteur for Mexico, where I could observe some peculiar features of the country's legal response that I would like to share today, and hopefully we will be able to discuss how this compares to other approaches. But it all begins with the constitutional structure. And, according to the Mexican Constitution of 1917, an old constitution, at least in terms of age, but it has been so reformed that it's now unrecognizable from its original form, of course. But broadly speaking, Mexico is a presidential federal republic. And this, of course, determines what kind of pandemic response we see during COVID-19. Public health, on the other hand, is the subject of concurrent competences between the federal and state level governments, it being a federal system, and the matters of public health are distributed across the country. However, the federal government will have a primary competence during national level public health emergencies, so emergencies that affect more than a locality or just one state. And I emphasize the word primary because, as we will see, this, of course, does not mean that the federal government is the only one to take action during an emergency. And in this regard, I must say, and of course, I'm cautious, it's quite similar to the constitutional structure in Brazil in terms of the distribution of competences. But of course, please feel free to correct me and point out to distinctions in this regard. And the core of the constitutional basis for public health emergency response is Article 73 of the Constitution, which enumerates or enlists the powers of Congress, yet curiously, on one of its sections, when it grants Congress the power to enact laws on public health, it includes a subsection where, as an exception to the rule that Congress will be the one to enact laws with general observance, in the event of a serious epidemic or risk of invasion of exotic diseases, meaning diseases coming from elsewhere, the Ministry of Public Health will issue immediately the appropriate preventive measures, which may be approved by the President of the Republic. So ultimately, it's the authority of the President of the Republic, but the Ministry of Health is the one that proposes the measures. And again, this is an exception within the general rule that Congress is the one with competence in issuing laws on public health. And because we're dealing with emergencies, this is then in a situation where the allocation of powers works differently than it would in ordinary times. And this provision, as you can see, it's quite broadly formulated, and it was already the subject of criticisms in the literature and constitutional law commentary already since 1981. So basically about 30 years before COVID-19 started spreading. A constitutional law scholar looked at this provision, Felipe Tena Ramirez, and labeled it a constitutional dictatorship. And apologies, it should read a sanitary constitutional dictatorship. So the Constitution allows for the sanitary authorities to take over these powers, and the limits, there are no clear limits to the powers that sanitary authorities may take, and through the President of the Republic, of course. Because two key issues in this problematic for him provision is that during a public health emergency, the executive may issue decrees with general effect, which are not reviewable by the Supreme Court, nor may be overridden by Congress. So neither the court nor Congress can overrule what the president decrees after a proposal of the Ministry of Health. And there are no sunset clauses mandated. These emergencies may last indeterminately. And since there's nobody to review and there's nobody really to overturn these emergency powers whenever they think they're not justified, there is a theoretical possibility that these emergencies may be extended even beyond their necessity, which, needless to say, can be quite problematic. And well, it will take then 30 years for this criticism to really, play a role for us to witness the consequences of the broadly formulated provision. And we saw this during COVID-19 when it came to the sensitive question, as Octavio Ferraz and earlier also Jeff King were describing, the sensitive question on whether to impose quote unquote lockdowns. So lockdowns is a colloquialism, and we try to avoid it to the extent possible in the Lex Atlas COVID-19 project and in country reports. But basically, it refers to these measures that suspend multiple activities. So when it comes to the decision of whether we will shut down economic and social activities, or whether we will allow them to continue with the potential consequences they may have for the spread of the disease. And in both of these decisions have devastating consequences. Unfortunately, this is a dilemma insofar as there will be a price for each decision, and it's a matter of determining who will make the decision to go one way or the other and to bear one set of consequences or the other. Which public authority then is the one to give the green light or the red light to these measures, one or the other? Measures or lack thereof in this case. Well, this being the core question, what we have seen in Mexico is that the federal government, through this emergency powers, as I mentioned, acquires primacy, meaning its measures, its orders are applicable nationwide, and states may not deviate from them. In this regard, the federal government sets a ground floor, insofar as it may include adopting certain measures, but maybe they will not adopt all of the package that constitutes a public health response. So besides this ground floor, states themselves may take additional public health measures. And we have seen this in Mexico. So besides the ground floor that the federal government has set during COVID-19, states have decided to adopt additional public health measures that the federal government maybe considered to be unnecessary. But nevertheless, that states with governors, with basically leaders, political leaders who are more risk averse than the federal government decided to go further. And they may do so under the Constitution. This is not prohibited. So state level authorities have the power indeed to take those measures beyond what the federal government provided for, as long as, of course, those measures are within the public health powers that they also have. They may, and within during the COVID-19 pandemic, for example, stay-at-home orders, which Jeff King discussed earlier at length, were the subject not of the federal government, but of state government measures. And here we can see an example of measures that go further. We've seen as how stay-at-home orders, so the order that the population and persons receive not to leave their domiciles unless under certain circumstances, these came from state level authorities because there was no nationwide stay-at-home order for multiple reasons. And we may agree or disagree with this decision, but the fact remains that so far in Mexico, we have not experienced a nationwide stay-at-home order, meaning even if we refer to what happened in Mexico as a lockdown, as we will see now, this does not go all the way as to really mandate people to stay at their homes. And in light of the dynamic nature of COVID-19, right, where the situation changes from one day to the next, needless to say, from 1 week to the next and from 1 month to the next. And in order not to have to resort to constant issuance of orders, one order after the other, where they had to update the current applicable measures, the federal government came up with the idea to legally create a self-renewing traffic light system, which was instituted through an order issued by the Ministry of Health. And it was published in the official gazette, as it must be, as a requirement for it to enter into force. Well, this traffic light system, what it basically foresees is the different types of activities that will be restricted depending on the severity of the spread of COVID-19 at a given moment. Right, so depending on the color, and there are 4 colors, so it's not exactly like a traffic light, or at least not the 3-color traffic light. We have different sets of activities that may be suspended, or that may be partially restricted, or in the case of the green color, that allow for all activities to be conducted without any restriction. Maybe through guidance to maintain a safe distance and to use masks, but activities may be conducted overall. So this traffic light would become the centerpiece of the legal response in terms of public health measures adopted to face COVID-19. And well, you can imagine that being in the, and I've now clarified that these colors applied at state level, so entire states, federal states, are subjected to a color, and the whole state is then that needs to respect the list of activities that are suspended, needs to abide by the list of activities that are suspended. And you can imagine that being in the red color will entail a major socioeconomic impact. Of course, it means that the spread of the virus is rampant, and that, and I'll come back to how these colors are calculated, are estimated. But needless to say, being in the red color means a lot of aspects of daily life will be disrupted. So how is every color of the traffic light calculated? So how do we know whether a state is experiencing a red or orange or yellow color? Well, we have what is known as the National System of Epidemiological Surveillance, which is the system that collects data basically health facilities or hospitals in this case report to health authorities, and these health authorities in turn transmit it to state level authorities, who then transmit it to national authorities. So it's a bottom-up system, which will determine indeed what type of measures will be in place at a given moment. And they already see that this communication of data will have an impact on people's lives. And the main indicator for determining level of severity is currently hospitalization rates. Jeff King was referring earlier to how reliable, we need reliable data, right? So this system is only as good as the data that is put into it, because otherwise, if it doesn't reflect what's happening, then it's not of much use. And well, the current system is heavily based on hospitalization rates, namely intensive care units, and how full are they. But since there is no systematic policy for testing in Mexico, we have unreliable data on infection rates. So we cannot rely on those because they might not be transmitting the actual severity of the spread of the virus in a given state. And just to give you an overview, a brief glimpse at what's currently happening in Mexico before I conclude. So we have a almost completely green country in terms of the severity of the spread of COVID-19, which leads many to assume and hope that the worst is over, so that we will hopefully be able to keep this under control. And this is according to the latest data. So this applies until the 20th of March, and most of the 31 of the 32 federal states can conduct activities as with, of course, certain precautions, but can conduct all types of activities. But of course, this leads us to a situation where it may become difficult in the future. Well, first of all, and we hope that we do not need to return to harsher measures in the future. And there are strong incentives for local or state level authorities to keep the traffic light away from the red color, right, or the orange color for that matter. As I mentioned, because of the impact they have on socioeconomic conditions. So what if some authorities are not providing accurate data, and I might add on purpose, right? What if they want to stay away from the red color, and for that purpose, they say, well, let's play a bit with the numbers in order to avoid really what is a very impactful decision. And this also relates to pandemic fatigue, right? Which means we are all very exhausted by these measures already. And there was an incident in August 2021 that highlights how this possibility is present. You see, in August 2021, the Federal Ministry of Health, and here through the Undersecretary for Health Prevention and Promotion, who is the mastermind behind epidemiological traffic lights, he was advocating and was recommending imposing the red color in Mexico City. And yet, he entered into a brief disagreement with the governor of Mexico City, who was in favor of the orange color in Mexico, in that city, because obviously that would allow her to avoid the most severe restrictions. And they were discussing on which data should be used, and the data that was reported that was subjected to interpretation. So basically, what we see is how these incentives play out in particular political dynamics. I might add that both the federal government and the government of Mexico City belong to the same party. So this is not a matter of opposition parties disagreeing with the federal government. So it is indeed a matter of different stakes, different interests at stake, that where the federal government wants this to be implemented, but state level authorities, of course, have incentives not to try to mitigate the impact of those measures. So we see how there's something as technical and as, let's say, dry as epidemiological surveillance can have a political dimension. And to conclude, so what about the global level? This is what happens at the national level. we can only imagine that if we look globally, as Act 19 aims to do, these dynamics will become multiplied, because of course countries may have an interest in not really transmitting reliable epidemiological data for multiple reasons, so that they transmit an image that everything is under control, or simply because they don't wish to be subjected to some restrictions on travel and so on by other countries. So this is a puzzle that is still very much present in the response to the COVID-19 pandemic. And indeed, Mexico is just one glimpse and one piece of this global puzzle that we're trying to face through the LAC 19 project. I thank you very much for your attention. Muito obrigado, and I'm looking forward to the discussion. Thank you.
Thank you, Pedro. Very compliant with your time. I appreciate. So I will pass on to Roberto, Magdalena, and Maricel for their presentation.
Okay, I will start. Okay. Well, first of all, I'd like to begin by saying that it's a pleasure for me to share this virtual space with all of you. Since time is short and three of us will speak, I will go straight to the points I want to reflect on with you. I'd like to begin by reflecting on the path chosen by the executive branch to govern during the pandemic. First of all, it's necessary to point out that both our report and these reflections are built under the premise that in a democratic society, reasonable disagreements around controversial public issues should be resolved through extensive political dialogue. The Argentinian constitution has been designed to demand at all times, and particularly on situations of emergency, the preservation of the principles that compose the basis of its legitimacy, democracy, and fundamental rights. Against this background, through the different procedural avenues it envisages, the Constitution demands extended democratic agreement for the adoption of rules and regulations. Decisions by a few, even if it's a group of experts, maximize the chances of losing relevant information and ignoring the demand and criticism coming from the public at large, and particularly those coming from the most disadvantaged. Having said that, and based on the regulatory framework I've just described, we can conclude that the path chosen by the executive branch is open to serious questioning. Even if we admit a certain relative autonomy of the legal reasoning with respect to those grounds, the reasoning on the rules is sufficient to allege the unconstitutionality of the measures adopted. Let's see why. According to the Constitution, the executive branch had three legal alternatives to deal with the pandemic: the declaration of state of siege, the use of delegated decrees, or the issuance of decrees of necessity and urgency. Of the three alternatives, we could say that the most burdensome is the declaration of state of siege, which enables the suspension of constitutional warranties. Although we agree that the declaration of state of siege was not propitious, the decision not to declare it doesn't enable the executive power to desnaturalize the use of other legal remedies, as happened in Argentina. The president resorted to the issuance of decrees of necessity and urgency. This type of decree, unlike the delegated decrees, doesn't require a previous intervention of the Congress to set the limits of the legislative matters delegated to the executive power. In other words, the executive becomes the legislator. The evident concentration of power implicit in this type of decrees has led to its absolute prohibition in the Constitution, with the exception of the existence of circumstances that make it impossible to follow the normal legislative procedure. The Constitution expressly nullifies its use when the conditions are not met. Likewise, the Supreme Court has stated that the admission of the exercise of the legislative power by the executive occurs under the condition of maximum exceptionality and in accordance with the formal requirements. Furthermore, the court has emphasized that it's an attribution of the judicial branch to evaluate the existence of the factual conditions that justify the adoption of decrees. The court had the opportunity to rule on this issue in the case related to the closure of schools, but decided not to do so, and instead it focused on issues related to federalism and disproportionality of restrictions. Within this constitutional framework, the executive branch has the burden of proving the existence of the condition set forth in the Constitution. However, the president didn't make great argumentative efforts. The successive decrees were justified on the existence of an unprecedented health and social crisis, the absence of an effective treatment, and the need to adopt quick and effective measures. Although at the beginning its use could have been justified due to the impossibility of a congressional meeting, once the Congress began to function, its use is null and void. The Congress began to operate in May 2020. Indeed, important laws were passed, such as the legalization of abortion. However, the decisions related to the management of the pandemic and the restrictions of rights that they entail still nowadays continue to be made by decrees and administrative decisions. To conclude, I would like to point out the need to analyze the response of the executive branch to this exceptional situation within a more structural problem of our institutional design. As Professor Gargarella has stated in his book, The Engine Room, the Argentine constitutional design, like that of other Latin American countries, was based on the American model of check and balances, but in the countries of the South, this system has become unbalanced in favor of the executive power. In the Argentine case, what is known as hyper-presidentialism results in institutional instability and authoritarianism. For this reason, in 1994, we decided to renew our democratic commitment, incorporating in the constitutional text greater controls over the power of the executive. For example, we regulated decrees of necessity and urgency, which until then had not been regulated. We can say that it was a modest and insufficient attempt, but I don't think that it overshadows the renewal of our commitment to greater and better democracy. In this context, the response of the Argentine state to the pandemic alerts us to the failure of our constitutional system to guarantee adequate institutional mechanism to control the abuse of power. On the contrary, we remain subject to the discretionality of political leaders with objections in terms of legitimacy that this entails. Thank you very much, and Magdalena will continue with other constitutional problems that we note in the executive's response.
Thank you, Maricel, and thank you to everyone for inviting me, and particularly Professor Gargarella. As Maricel just pointed out, on the one hand, there are constitutional requisites regarding how the measures to tackle the pandemic should have been taken. And we can consider what she just presented, procedural implications of this constitutional analysis. But on the other hand, there are as well substantial implications to how these measures should have been taken. And those stipulations particularly stem from Article 19 of the Argentine Constitution. Article 19 provides that the private actions of men and women, which in no way offend public order or morality or injure the rights or possessions of third parties, are exempted from the authority of judges. And moreover, it provides that no one should be obliged to perform an activity that is not required by law, nor deprived from what the law does not prohibit. And in 2009, which is coincidentally the same year of the emergence of H1N1, the Supreme Court of Argentina rendered its decision in the Arriola case, which analyzed the constitutionality of the criminalization of the possession of cannabis for personal consumption. And in that case, the Supreme Court understood that Article 19 forbids the state from prohibiting any conduct that does not imply any related concrete danger or injury to a third party's rights or possessions. And in 2020 in Argentina, to tackle the pandemic, contrary to what Pedro explained before, the federal executive, through Decree 297 of 2020, did establish a federally imposed stay-at-home order. And at the time, as Marisol said, procedurally, this being established by the federal government, by the federal executive, could have made sense constitutionally, and substantially, we could say that the uncertainty of how COVID was spread could lead to an understanding that these general broad measures were necessary, and therefore that the concrete danger of specific activities led the government to those restrictions. But as the time passed and over the months, the international community gathered a greater understanding of how COVID was spread. Certainly, these broad restrictions should have changed, and that is our understanding and the understanding of the report that we presented. However, notwithstanding that certainty, the reality shows that the federal executive maintained these very broad restrictions. And evidently, in a way that what that shows is that the assessment of concrete risk in these cases towards these certain activities seem to circumvent the stipulations and the guarantees provided by Article 19 of our Constitution. Today, I would like to highlight two specific cases that I believe illustrate very well this situation. First is the prohibition of physical activities and physical exercise in public spaces. And secondly, the closure of schools, which of course is not a particular case of Argentina, as Pedro has just told us about. First, the prohibition of physical exercise takes us back to July 2020, when running and any sort of exercise was prohibited outdoors due to the COVID restrictions that were federally imposed. And the executive's reasoning as regards this measure was that, of course, physical activities would lead to a sort of effective elimination of the stay-at-home order, because it would be it would be almost impossible to analyze whether someone was running or maybe doing something else. That was the understanding. And therefore, what they say is this would lead to much more COVID cases. However, contrary to this understanding, the reality shows that any outside activity decreases greatly the risk of contagion, and therefore this evaluation of risk fails the standards stipulated by Article 19. And the other example, which we wrote with Maricel about, and we published a blog post at the Lex Atlas website, is of course the closure of schools in Argentina, which I believe can be considered one of the most drastic measures that were taken by the federal government. And originally in March 2020, this was supposed to last 14 days, but it ended up lasting for the entire 2020 school year. And afterwards, again in 2021, particularly in April 2021, the federal executive decided to again close the schools due to a new COVID wave. And at that time, what is particularly interesting is that the city of Buenos Aires decided to challenge this decision and presented before the Supreme Court a request for a declaratory judgment, understanding that this decision by the federal executive was unconstitutional. The cities particularly challenged the data that was put forward by the federal executive to base this decision, but also it said that the decision per se failed a necessity test. This was briefly talked about as well by Maricel when she was analyzing this procedural aspect of the constitutional analysis of measures. And what she said is that the court decided not to touch upon how these measures were imposed. Contrary to that, the court did analyze briefly the substantial issue of the necessity of these restrictions. Generally, as Maricel also pointed out, the reality is that the court understood that the federal executive was breaching the autonomy of the city, but most importantly to our analysis, what was also said was that even if the pandemic would allow for the federal executive or to the government in general to restrict the right to education, those restrictions should not impair the essence of the right to education. And what the court understood is that in this particular case, when the length of our restriction affects the quality of education, therefore clearly this measure does not pass the necessity test, and clearly there was no concrete danger as required by Article 19 that would amount to such heavy restriction being imposed. And also as well, what I consider that is particularly important when analyzing this heavy restriction to the right to education are the huge inequalities of our region. Today, we are talking about Latin America, and therefore we cannot shy away from the reality that our children do not have the same possibilities throughout the region. So regardless of that, to sum and to pass the word to Professor Gargalela, as I said, I believe these two examples very well illustrate how the government, the federal authorities failed to analyze the concrete danger that these certain activities had when imposing these broad COVID restrictions.
Thank you. Can you hear me? Yes, I just want to add a few footnotes to what Maricela and Magdalena said. But before thanks for the invitation, and I also want to make public my congratulations to Maricel, Magdalena, and all the team of young scholars that we had, who did an incredible job. And so just a few footnotes. I think that the cases that they were just presenting on exercises and closures of schools are extremely important. In a way, are like as Borges would have said, in a way they are like our Aleph. If you look through them, you see the whole law in Argentina. So, I mean, all important cases allow you to see the whole law, but these two situations are, I would say, extraordinary for understanding how the law is being developed. And in particular, I just want to link these two cases and what they allow us to see to what Octavio was saying at the beginning, because they speak perfectly about all his main concerns about how these decisions were adopted, and particularly in terms of what the executive was doing, under what authorization. Second, among the amount of public discussion behind these issues. And third, the issue of opportunism that he was also highlighting. And I think they allow perfectly to understand all these points. I would just make a little, not confession, but opening or about the kind of discussions we had within our group. In a way, for good or bad reasons, I tended to have a kind of more radical, this could be good or bad, position in the discussion, because it was, as both Maricela and Magdalena mentioned, it was uncertain, or I mean, there was some margin of doubts at the beginning regarding the legal authorization for the president for doing what he was doing in the way he was doing, because the Constitution allows in a very restrictive way these decretos de necesidad de urgencia, but they allow these decrees only when there is an impossibility for Congress to develop this discussion. So one could have argued at the very beginning that there was an impossibility. I myself, just paying attention to the examples in Europe, which in a way had to go through all this discussion before, we could see that there was not an actual impossibility. I mean, I remember in particular the cases that were more important here, the case of Spain, that, well, you could go to Congress, you could ask authorization, etc., etc. So from the beginning, I was saying, I mean, this is not authorized by the Constitution, and it was important. But in any way, although there was this margin of doubt at the beginning, it then very soon it became clear that that there was no legal reason for allowing the president to do that. And as Maricel was saying, I mean, this criticism that in a second stage, early stage, we all share, fit very well with the way we tend to understand the Constitution and how a constitutional democracy works, which is all important issues that affect all of us are issues that we need to be able to get involved and discuss. And so at the beginning, many of us, we were saying, well, many of the decisions that our experts are adopting at this point, with the best faith, good faith, well, are decisions that are heavily mistaken because of the way they were adopted. Because this mandate of stay at home and wash your hands in situations where people have no access to water and they are living 10 people in the same room, well, of course, I mean, these are advices that may be reasonable in Europe, but they are completely unreasonable in countries like our countries, and particularly here in the Gran Buenos Aires. But then the issue of schools, the closure of schools, is even more dramatic because the vast majority of the educational community said, this is crazy. I mean, there is no reason to do this. We can go through much less drastic measures. And they were saying just no. So this idea that not being sensitive and not being willing to be open to the democratic discussion, I mean, was not only offensive to our democratic creed, but also was clearly at that point against what the Constitution reasonably demands. I mean, these kind of decisions need to be adopted in a different procedure, and this is what you have to do. And the true and the report, I think, has that virtue, is that we were kind of alone from many months in pointing and insisting that these decisions were against the law. So in that way, I wanted to praise the work that was done by the team, because I mean, it was, I think, quite important for the public discussion to have a team of scholars thinking about these issues from the legal point of view. And the final point I want to make is about the opportunism. And I think that, again, Argentina, as many Latin American countries, gave a good example of this, in the sense that concentrated political authority used this opportunity to concentrate even more the power of decision, and in particular, and this was important in Argentina, but I think it was even more important in other countries, and I would like to hear more, for example, about the case of Colombia now, but in terms of listening to divergent voices, to paying attention to the voices of people in the street protesting. So in Argentina, we have many cases on this regard, and we have many polemics in this respect, but I think that the situation was even clearer in other countries in Latin America because of this kind of opportunistic behavior. So using the opportunity that this super evident crisis was created in order to concentrate authority and use the coercive powers of the state in an illegal and, I would say, immoral way. But so yes, the case of Argentina provides very good illustrations of the kind of concerns that Octavio was presenting at the beginning. So I stop with that. Thank you.
Thank you, Roberto, Madalena, and Maricel. I will pass directly to Diego to talk about the Colombia case.
Boa tarde. No primeiro lugar, eu gostaria de expressar a minha gratitude como a Fundação Getúlio Vargas pelo convite a participar neste evento. Em 2016, eu recebi um convite da Universidade de São Paulo para fazer uma pesquisa lá. Em São Paulo, eu tive a oportunidade de visitar a Fundação Getúlio Vargas e conhecer alguns dos maravilhosos professores da Escola de Direito. Por isso, este convite me faz muito feliz. É um prazer compartilhar e dialogar com vocês neste evento organizado por esta importante Escola de Direito na América Latina. Now I'm going to speak English in order to dialogue with my colleagues. In particular, I am very grateful with Professor Octavio Ferraz. It is also an honor to take part in this panel along with Professors Pedro, Roberto, Magdalena, Raquel, and Maricel. This presentation is based in the Colombian report for the Lex Atlas COVID-19 project directed by Professors Octavio and Jeff. This report, the Colombian report, was written by my colleagues, Carlos Bernal, Sebastián Rubiano, and Maria Barraza. Though this presentation just portrays my personal opinion on the COVID-19 responses, it does not represent the institutional position of the Constitutional Court. I am going to refer to the Colombian responses to the COVID-19 from five perspectives, from five criteria in three different phases. The criteria are, first, institutions and checks and balances. Second, normative arrangements. Third, rights and judicial enforcement. Fourth, non-discrimination. And finally, public expenditure and fiscal deficit. I am examining those criteria in three phases: pre-pandemic, pandemic, and post-pandemic. First, institutions and checks and balances. The 1991 Constitution of Colombia institutes a social and democratic state. It organizes the state as a unitary republic with a presidential political regime. It establishes the principle of separations of power, the rule of law, the principle of the supremacy of the Constitution, and also it guarantees the human dignity and the fundamental rights of individuals. According to the Constitution, the President of the Republic and the ministers form the government. They exercise the executive power at the national level, though we also have governors and mayors invested with executive power, respectively, in their departments and municipalities. The Constitution grants the President ordinary powers to preserve public order and sanitary conditions, but also the Constitution grants the President extraordinary powers on a temporary basis with important constraints. Those powers have to be exercised without jeopardizing intangible rights and suspending fundamental rights, interrupting the normal operation of the branches of public order, or eliminating the functioning of the judiciary. The Constitution also prescribes political accountability mechanisms to control extraordinary powers. Finally, Articles 215 and 241 of the Constitution empower the Constitutional Court to review ex officio automatically the constitutionality of the emergency powers decrees. COVID-19 brought about dysfunctionality of all branches of public government. The executive rulemaking powers played a dominant role in the policymaking activity for addressing COVID-19. The President enacted almost every policy concerning the crisis by exercising either ordinary competences or extraordinary competences to adopt legislative decrees. Overall, the President promulgated an unprecedented amount of 189 ordinary and legislative decrees. One thing which is very important is that none of the measures or policies related to the pandemic changed the basic institutional arrangement I just mentioned. The judiciary, I would say, had a better capacity to continue in service in spite of the difficulties of the crisis. In particular, the Constitutional Court has reviewed, or did review, the constitutionality of all legislative decrees. It declared 57 of those decrees constitutional, 7 of those decrees unconstitutional, and 51 partially constitutional. The legislative, in my opinion, was the most effective branch of the government. It only passed one law and had no major outcomes in terms of political accountability. Now, in the post-pandemic phase, I think that we have had important questions on at least 2 topics regarding institutions and checks and balances. First, how to implement adjustments to better political accountability mechanisms for this kind of crisis, for super crises like the COVID-19 one. And second, how to adjust judicial mechanisms to avoid problematic delays regarding judicial review of extraordinary and ordinary policies in the framework of this kind of crisis. Second, I am going to refer to normative arrangements. First, pre-pandemic legislation was the basis to adopt public health measures. In particular, an statutory act from 1979 authorizes the Minister of Health and Social Protection to regulate epidemiological surveillance and to isolate individuals to avoid disease transmissions. In the pandemic, I would say that from the normative arrangement perspective, we faced 2 phenomena. First, hyperproduction, and second, one phenomenon which I called a kind of a schizophrenia, normative schizophrenia. The normative hyperproduction is explained because of the high amount, the unprecedented amount of norms enacted by the president. As I told you, the president enacted 189 decrees plus all kind of domestic soft law regulations, protocols, guidelines, etc., on different areas such as public services, public finances, taxes, private companies, social assistance for vulnerable communities, the core system itself, employment protection, and public contracts. As I mentioned, this is just 189, decrease plus a tremendous amount of domestic soft law, an uncountable amount of domestic soft law enacted by local agencies, regional agencies, and national agencies. We also had a phenomenon of normative schizophrenia. And I think this is so because of the uncontrolled normative production. The president, ministers, regional authorities, administrative agencies, local authorities produce a tremendous amounts of norms that truly gave place to a chaotic normative situation. Now, in the post-pandemic phase, I would say that we have a very important challenge, which is a task of normative depuration in order to mitigate that chaotic normative situation that we went into because of this hyperproduction and schizophrenia and normative schizophrenia, production schizophrenia here in our country. Third, I'm going to refer to the third criteria, which is fundamental rights and judicial enforcement. I would say that our Constitution prescribes a system of rights and judicial enforcement mechanisms for normal situations. In my opinion, the pandemic shows that this system was thought and is operative mainly for normal times. In Colombia, we have a very long catalog of fundamental rights and numerous judicial mechanisms to protect those rights, and we have a very rich case law regarding protection of fundamental rights for situations of normality. However, in the pandemic, we have several and important restrictions on rights that are unprecedented in our country. We had mobility restrictions, curfews, lockdowns, restrictions on international and domestic travel, limitations on public and private gatherings, closure of facilities, physical distancing, use of face covering, and limitations to have access to health and public services for impoverished communities. I would say that because of its magnitude and its frequency, those limitations and restrictions to fundamental rights are unprecedented in our systems and really challenge our system of rights and judicial enforcement of those rights according to our Constitution. Now, in the post-pandemic, I would say that we have two main challenges. First, a question about how to harmonize rights protection with crucial and tremendous crisis of this magnitude that we have faced. And second, how to improve the judicial system for it to be able of protecting rights and controlling the powers in context of this super crisis. Fourth, I'm going to mention the fourth criteria, which is non-discrimination. Article 13 of our Constitution prescribes the non-discrimination principle, the non-discrimination prohibition based on race, gender, sexual orientation, age, etc. In the pandemic, the government adopted curfews and lockdowns based on gender and age. For instance, many measures of adults of 70 years to stay home because preventive mandatory isolation. And we also face episodes of violence against transgender population that challenge the non-discrimination prohibition. Regarding that principle, regarding the non-discrimination principle, I think that in the post-pandemic era, we have one particular challenge, which is how to assess and evaluate rationality and proportionality of restrictions to the non-discrimination principle in context of crisis, especially because of the ample margins of government's discretionary powers that are needed to overcome the crisis. Finally, the fifth criteria is public expenditure. Before the pandemic, Colombia faced important budget constraints and notable inflation. During the pandemic caused a substantial increase in government debt, public expenditure, and fiscal deficit. And I think that that increase was also unprecedented, and it was an exponential increase of public expenditure and fiscal deficit and government debt. I think that now in the post-pandemic phase, we have a very pressing issue, which is how to deal with fiscal stability in years ahead. Why? Because during the pandemic, we suspended the fiscal rule for years ahead. We took great portions of budgets from pensions funds, and we took great portions of budgets from labor funds and territorial funds. So I think that that's probably the most pressing issue regarding public expenditure and fiscal stability that we are facing in this phase, in the pandemic, in the post-pandemic phase. So I think that these are the main highlights that I wanted to share with you. I will be very happy to share thoughts with all of you about these ideas. And once again, thank you very much for this invitation.
Thank you, Diego. And last but not least, Otávio will talk about Brazil.
Thank you very much. I hope that everyone watching this agrees with me how great this enterprise has been, and I'm dreaming here of having like more meetings like this with the other regions that LAC 19 covers. and even a global meeting. We had funds in the grant to organize a couple of conferences, one of which has already passed because of pandemic rules. We weren't able to do it. So let's hope that we managed to do a final one, at least with rapporteurs from around the world in London, sharing this amazing experience that has been to produce these reports. So I will try to share again my screen. Can you see it now? Now you can, right? So because when I was listening to Maricel, to Madalena, to all of you, I was thinking that it would be great for the people on YouTube to be able to actually have a taste of what we are talking about. So here is the Oxford Compendium of National Legal Responses that everyone can access. And here is the list of reports so far published and all the people who have contributed to it. You can see it's a huge and long list, and it will be even larger when we have all the 60 there. So you can, I'll just click on Argentina because it's the first one, and you can see what I was mentioning in the beginning, that they all share the same framework. So it's parts 1 to 4 so far, parts 5 and 6 will be added soon. And you can go to it, any report in the compendium, and you have the exact same framework to enable comparison, as I had mentioned. The other thing I wanted to also highlight is our website, and it was either Maricel or Madalena or both who mentioned that they have a blog post there. So all blog posts come to the main page here, and we divide it by country. So there's quite a few recent ones. And here is, I don't know if this is the one you were mentioning earlier or if it's an earlier one, but if you go to Argentina's webpage, again, I'm using Argentina here just as an example, you will have an overview, a link to the country report in the Oxford Compendium, and also some data on the situation there. And here, all the blog posts that they have already published, and the names and pictures of the rapporteurs and the contributors there for you. Okay, so I will, given we had already had 3 great presentations and the time is ticking, I will try and be a bit more concise in my presentation about Brazil to allow some time for discussion. So I just wanted to thank first my co-authors in the Brazil report, Professors Conrado Rubner Mendes, Daniele Rached, Daisy Ventura, and Marco Antonio Moraes Alberto, who, like in the Argentinian team, made like this much easier and richer than it would be with just a single person like me writing it. I don't have the capacity like Pedro, or other single rapporteurs to write so well and efficiently in all of these areas. So the Brazil one is also a multi-authored report. Now, Brazil is, as you may know, one of the countries that suffered most with the pandemic. According to official figures, we have 650,000 deaths, actually a bit more than that at the moment, which makes us the second country in terms of absolute numbers. And according to the Economist excess deaths method, we really have more than that, about 780,000 deaths, or 360 per 100,000, which I think is a better way of looking at deaths, because it takes into account, obviously, the size of the country. And for those of you who are not familiar with this data, I would recommend the Economist's web page and resource called The True Death Toll of the Pandemics, where they actually compare official numbers. So according to official numbers, there would be about 6 million deaths in this pandemic so far. According to their estimates, which is based on this concept of excess deaths, which is all the people who have died during the pandemic for whatever causes, which are more than what would be expected for the same period according to historical data, then it's really incredible how it would jump from a minimum of 14.1 million and a maximum of 23, and then somewhere in the middle, which is what the methods to estimate the confidence of this data show, is about 20 million. So there would be at least 3 times more deaths, they estimate, if the reliability of data, which is something that Pedro highlighted in his talk, was better. And that applies for the whole world. Obviously, some countries have bigger gaps between official data and the estimate data that they do. And then you can compare countries here, and I put Brazil and Argentina here side by side. Can you see this? Yeah, okay. To show, so according to official data, Brazil has 304 deaths per 100,000, whereas they think that the more realistic number would be 360. Argentina has 277, whereas the more realistic data is very similar to Brazil. And you can compare here with any country that you want. Let me just do one more comparison, maybe again in Latin America. Let's see Costa Rica, and then you have 150. The estimate is actually lower than the official one, so 157. So less than half the death toll of Brazil and Argentina per capita, and the official and estimate data doesn't vary so much. So what does, I think this is a good way of illustrating how countries, even with similar constitutional, political, regional characteristics, have varied significantly in terms of what we could say the outcome of their pandemic response, and how important it is to investigate why that happened. And as lawyers, I think we are particularly well placed to investigate what we call in the LAC 19 project, the legal determinants of pandemic responses. So how did the legal systems of each country and how the legal institutions operated during that time influenced in the outcome of the pandemic? Now, if we think of countries like Norway, Australia, New Zealand, then the comparisons become even more striking. New Zealand, so remember, Brazil, 360 deaths per 100,000, New Zealand, 1.19. So if you think, oh, New Zealand is a really small island, it cannot be compared and all of that, I think we can compare, but obviously there are some issues to be taken in consideration. Well, Australia, 20. Norway, 26. Germany, 149. So there is a lot of variation there that needs to be explained if we want to hold governments accountable for responses. And I hope that the LAC 19 project might help us with that as well. Now, about Brazil, I wanted to highlight a couple of issues only, which I think stand out when we think about how Brazil responded to the pandemic. One is how federalism actually had a very important impact in our response. And the other one is the role of courts and the interference of courts, in particular the Supreme Court, also had a very important impact. So many have concluded a bit hastily that what explained this quite bad result in Brazil, so even according to official data, 300 deaths per 100,000 puts Brazil on the top 5 countries with most deaths around the world, right? So one of the worst outcomes of all across the world. But many people hastily came to the conclusion, oh, of course, like you have a president in the helm there who is a denialist. He infamously called the pandemic a little flu, a gripezinha. He deliberately encouraged the population not to follow local pandemic rules. He himself defied the rules and appeared in public without a mask, made gatherings like around him of hundreds of people sometimes during the worst times of the pandemic. So no wonder that Brazil has such a bad outcome. However, and this is where the first point here is important, Brazil is a federal country. And as Pedro was mentioning there, the competence to respond to the COVID pandemic is concurrent, and therefore states and municipalities were not just able to implement pandemic measures which went against the federal level view, but they actually did so. So when we look at the states in Brazil, and the LAC-19 could not obviously survey all the states, that would be an impossible task, but we focused in each of the federal countries on 2 sub-national units. We focused on São Paulo and Amazonas, which are very different in terms of differences. Amazonas, very low density of population, huge geographic area, most of it covered by forest. São Paulo, like one of the most developed states in Brazil. And they both adopted very strict pandemic measures like lockdowns, defying the federal view. And they both had very bad outcomes as well, across 300 per 100,000 deaths. So I'm not trying in any way to justify the president's conduct during the pandemic. I wrote a blog for our website, which is called The Crimes of the President. And I think he was criminal during the pandemic and should respond for that, if not in the International Criminal Court, as many people hope, at least internally, when he eventually goes out of power and loses his immunity. But so I'm not trying to protect in any way the conduct of the federal government, but from a scientific perspective, we have to investigate further. How come the outcome was so similar in state units who did have the power and did adopt pandemic measures which were quite strict? And this is where I think the LAC-19 can contribute, because we can compare with other countries. We can look not only at the official formal measures that were taken by all these countries, but what we call in the reports, enforcement and compliance. I think this is perhaps the most difficult but very important aspect that we have to look at, and that was already mentioned by some in the morning and here in the afternoon session as well. It was Siri Gloppen earlier on here today who was saying that trust is really important and something that we should look at. We actually try to look at that through the compliance aspect, because many people believe that the gap between the formal rules and how people complied with them is related to trust, and that has an impact on the outcome of the pandemic. If more people comply with the pandemic measures, you have lower death rates, irrespective of what the rules in the books are, what law in the books are. Now, in Latin America, as I think it was Madalena who mentioned already, we have to take into account the huge inequalities of the region, which really made it difficult for large sections of the population to comply with measures which basically would condemn them to starve if they really complied with them. People in the shanty towns, I wrote an article in the beginning of the pandemic referring to favelas in Rio, in particular Rocinha, where people, even if they want to, they cannot comply with social distancing measures. If you live in a shanty town where your whole family is sharing like a room where 10, 12 people live together, how can you maintain social distance? How can you stay at home and not go out to work if you are an informal worker who depends on selling in the streets, pão de queijo, like cheese bread or coffee or et cetera, et cetera. So I think all of that has to be taken into account alongside the formal rules of the pandemic, which we are also mapping out, but this is going to be an interesting aspect to look at comparatively in the future. And to go back to the one I was highlighting about Brazil, so the federal structure of our system, alongside a decision very early on by the Supreme Court, which blocked some of the president's attempts to stop states and municipalities from adopting pandemic measures, is very important to know if you want to understand Brazil's response. So on one hand, there was a lot of local, regional and local, state and municipal measures which defied the federal view, and that was supported by a case in the Supreme Court, which said, yes, the Constitution does establish these concurrent competences, and that doesn't apply a ceiling. So I was interested, Pedro, in your floor idea that the Mexican Constitution establishes a floor that the federal level sets, and then all the others have to follow. In Brazil, the decision was the opposite, that the federal level cannot establish a ceiling, which is what the president had wanted in the beginning, by regulating essential activities and putting everything there, basically trying to undermine any kind of lockdown. The Supreme Court said states and municipalities can go well beyond the national level and as high as they want, basically. So that was very important. But even with those stricter measures, the outcome was still bad. And we need to look at these other important potential explanations like compliance, inequalities, and that's something that the LAC 19 will try to do. And secondly, and finally, and I want to stop to allow some time for discussion, is the very active conduct of the Brazilian courts during the pandemic. Now, this won't surprise anyone who is familiar with the activism of Brazilian courts, especially the Supreme Court in all areas. So it would be a surprise that the courts would behave differently during the pandemic rather than the other way around. Jeff was talking earlier today that in many countries, we actually saw already differential courts, traditionally differential courts, becoming even more so during the pandemic because they gave a lot of leeway for executives to determine what the measures should be. But in Brazil, it was the opposite, and probably because of the stance of the federal government of being denialist of the pandemic. So we had decisions in the Supreme Court, which we are going to discuss in much more detail on Thursday on a table with Daniel Wang and the FGV people who are studying this in a lot of depth in Brazil. So we had decisions as well as the federal conflict one, which I mentioned already, decisions trying to protect indigenous people, decisions suspending police operations in favelas during the pandemic, which was a very important issue. If you imagine, I have already mentioned how bad the situation was of people not able to socially distance, having to go out to work, and also having the police invading from time to time to get into these conflicts with drug dealers that always result into the deaths of innocent civilians during a pandemic. So there was a decision of the Supreme Court which suspended police operations in favelas during the pandemic, which was very important. And finally, vaccination. As you know, one of the things that the federal government tried to delay as much as it could or stop the vaccination program. And again, a decision of the Supreme Court determined that the federal government, and this is a federal issue, it's hard to do a vaccination program sub-nationally in states and municipalities. It prompted the government to finally start the vaccination program, which was very relevant as well. So we only have 15 minutes left. So I just want to thank again everyone and say we should have other meetings and bring people from across the world to get into this really nice dialogue we started today here with Latin America. So back to you, Raquel, to the questions, if there are any from the YouTubers. Thank you.
Thank you, Otávio. What a superb panel we've been watching. It was such a pleasure to learn more about each country. While we're still waiting for questions from the audience, please feel free to send it through the Slido link that is there in the video. I will maybe do a self-indulgent question and ask all of you something that is of particular interest. So I guess the theme I wanted to ask how it has been the legal responses in each country is transparency, because in one hand, we have seen this massive amount of data coming out of the governments, either on how the pandemics were being dealt with, the death tolls, as Otávio just mentioned. And in the other hand, we have seen also some governments having more and more discretionary power, concentrating power, and sometimes withholding either information or other, more transparent measures from the population, from journalists, from the civil society in general. So this is very self-indulgent, but while we wait for another question, I wanted just to ask you if anyone could share some experiences on their own countries.
Can I start just quickly mentioning that the Lex Atlas, the compendium, does ask some of questions which are quite closely related to this one, and perhaps the most relevant here is the freedom of information and how the press was affected by pandemic measures. So the pandemic opportunism that we've been talking about, and Roberto mentioned that Argentina is a great example. There are many in the Lex Atlas, and this will be one of the topics we'll be exploring in our analysis, and will probably be in the final book, which we are going to edit with many of the most interesting analysis. So this pandemic opportunism, one of the areas in which we saw that a lot was in information. So many governments took advantage of the emergency to do several things which limit quite considerably the freedom of the press and individuals to talk about the pandemic, to report on pandemic data that affects death numbers. So Russia, for instance, which is quite obviously prominent at the moment for really sad reasons, they did that quite a bit. So limit even further than it already was, the power, the freedom of individuals to report through criminalizing fake news. So fake news, according to whom, right? If you put it very broadly, as China was another example, then anyone trying to criticize the pandemic response of the government is caught into this net. In Brazil, there was an early attempt by the government to suspend freedom of information requests during the pandemic, but that again was reversed by a Supreme Court decision, saying that, and I think a bit like Roberto was saying, that the Argentinian case, there wasn't any need to suspend the scrutiny of parliament to respond to the pandemic, and we can see that that's true because many countries did so. The same about freedom of information. Why stop freedom of information requests during the pandemic? The only justification can be like to stop the flow of information, right? So we in the end was reversed by the Supreme Court. So I think these are two good examples. But in the compendium, you have both positive and negative examples of how transparency has either been limited or enhanced sometimes during the pandemic with daily reports by government, something which you don't get in normal times about what they were doing, and real scrutiny from the press. The UK, where I live, was one of the examples. Every day, the government had to be there on TV, on BBC, answering questions from the public, from journalists about the pandemic. Anyone else?
I see Diego, Diego and then Pedro.
Thank you.
Roberto as well.
Yeah, I would say that reporting on COVID-19 by the media was not constrained by the executive during the pandemic. The government in Colombia issued two measures to secure COVID-19 reporting. First, it exempted press reporters from mobility restrictions. That was the first measure. And second, it declared that television was an essential service and its functioning could not be suspended during the crisis. However, the Organization for the Free Press, OFP, denounced that the executive limited the freedom of press for two reasons. First, they argued that executive authorities didn't issue sufficient measures to protect reporters from biological risks. And second, they claim that government ordered mass media companies to disseminate official information related to health emergency and the measures taken by the government. So the OFP considered that such behavior entailed a form of government propaganda. That's from the Colombian side.
Very interesting. Pedro or Roberto?
Pedro.
Gracias, Roberto. Just to follow up on Diego Gonzalez's comment on, the press was also declared to be an essential service in Mexico, and of course along the radio and television. And I do believe, like Octavio said, that there was an unprecedented transmission of information on a daily basis. I showed the picture of the Undersecretary of Health who was every day explaining to the population, this is what we're doing and these are the reasons. I think the problem the challenge rather for the press is, although they did have access to information, it was very difficult for outside observers, people outside of the government, to really challenge or to really question some of the data, because some of it is really only the government has access to that data. So if somebody will want to really come up with data that somehow contradicts the information that the government has, they would have a very, very hard time because they don't have access to the hospital records. They don't have access to other information that is only transmitted to the government. So to me, the challenge was indeed going back to the issue of trust. Even if that information was made available, it ultimately came down to what extent the population and the press trusted the government that the data they were providing for was accurate, because it's very difficult for them to challenge that data on its merits. Thank you. And now to Roberto, gracias por la oportunidad.
It goes to Magdalena first, and then I say something.
No, what came to my mind, and it's something that we highlighted in our report, besides the federal government, and I think probably Roberto will touch upon that, our report also covers both the city of Buenos Aires and the province of Formosa. And in the particular case of the province of Formosa, what happened was that people coming from outside other provinces could not enter the territory of Formosa. And what ended up happening was that news outlets wanted to go and see what was going on in Formosa, and for a long time that was not allowed. So yeah, exactly what we are seeing right now. And eventually what ended up happening is that luckily a team from Buenos Aires secured an habeas corpus and was able to go and broadcast what was going on in Formosa to a federal level, let's say. But that was what came to my mind. I don't know if Roberto would.
No, yes, that's a crucial case. So in our federalist picture, I mean, the case of Formosa is the one that gathers the whole horror show. But no, I wanted to say something more general that is in the case of Argentina. I think like perhaps in the US of Trump and the Brazil of Bolsonaro, the issue, the discussion was very much involved with these issues of centralization, politicization, and polarization. And so I wouldn't say that what was dominant was censorship, particularly because the civil society was actually divided and mobilized. So we were all alert. But the discussion was very much touched and involved with this issue of polarization. So at that time, the government created an institution that then it became that was completely incompetent, but this is an official institution that was in charge of examining, scrutinizing fake news. So this was totally ridiculous. Nobody knew exactly what powers were going to be given to the institution, what if they were going to have, I mean, capacity of enforcing something or sanctioning. But well, it then became that, I mean, basically because the reaction from civil society was strong, that they had to step back and basically the institution exists, but is as inoperant as expected. But this was an issue at one point that this institution was created. So to confront the fake news that basically was saying, I mean, actually what it implied was to show that everything that the opposition was saying was fake or things like that. So that was an important event which had a public official response, but then it became as incompetent or meaningless as expected.
Thank you all for sharing your thoughts on this topic. If we do not have any further questions from the audience or from any of you, I think we're about to hit our end time. So if not, I will just thank all of you once again. This was a superb presentation. Thank you. I hope we can meet in presence anytime soon. And to all of you who are watching us, this is the opening week of the graduate program. So stay tuned for the other events and for the other panels that are coming the next days.
Thank you. Gracias a todos.
Thank you. Obrigado.
Gracias, muito obrigado.
Feliz dia.
Saludos a todos. Gracias.
Bom dia.
Saludos.
Saludos.